Good morning, ladies and gentlemen. Today, June 30, 2020, there was again another friend of ours who volunteered to discuss extensively criminal law 1 by the name of Alvin Taranco. Alvin Taranco is the current dean of criminology of the University of Eastern Pangasinan. If I'm not mistaken, he also worked as the former dean of St. Rose Paniki Tarlac. He finished his Bachelor of Science in Criminology at Pan Pacific University way back 2005. And when he took the licensure examination during that time, October 2005, he landed as number 5 nationwide. He also finished his Master of Science in Criminology at Pan Pacific University and Bachelor of Laws also at Pan Pacific University. So this is perhaps the classic example of direct articulation. At present, he is taking up his Doctor of Philosophy in Criminology at the University of Baguio. And as I told you, he will be discussing criminal law 1. I'm not going to get so much time in introducing him because his discussion in the subject matter is a little bit long. So again, please welcome the Dean of Criminology of University of Eastern Pangasinan, Alvin Taranco. Thank you.
Good day, everybody. My task is to talk about the Criminal Law Book 1. What we need to know about criminal law, Book 1. The criminal law was created under Act number 3815, also known as the Revised Penal Code of the Philippines. The Revised Penal Code of the Philippines comprises 2 books. The Book 1, covering the basic principles affecting criminal liability under Article 1 to 20, and the penalties, covering Article 21 to 113. The Book 2 covers the Article 114 to 367, talking about the felonies within the different titles. The Revised Penal Code took effect on January 1, 1932. And this Revised Penal Code, as I said, covers your Criminal Law 1 and Criminal Law 2. As you can observe in Criminal Law 1, it talks about the basic circumstances affecting criminal liability. In other words, you will study here, you will be able to learn what are the basics pertaining to criminal law, as well as the penalties imposed herein. Revised Penal Code is also known as our criminal law. And when we talk about criminal law, it is a branch of law or division of law which defines crime, treats of their nature, and provide for their punishment. That is the very nature of a criminal law. It is a branch of law that first defines crime, second treats, their nature, and the third one, to provide punishment. That's why, as you can observe, in if you go to the other articles wherein we are now talking on the felonies, there it's stated the definition of the crime, the traits or the nature of the crime, or what is that crime or where that crime is being categorized, like crimes against person, crimes against chastity, crimes against properties, and others. And on the next sentence or paragraph, you can find there the punishment provided for such crime. And that is because that's the nature of our criminal law. It defines crime, treats its nature, and provide for their punishment. And because it's a criminal law, our main concern is about crime, because it's the crime which will be punished by this criminal law. Basically, crime is an act committed or omitted in violation of public law, forbidding or commanding it. As you can observe in the simplest definition of crime in its legal context, it is an act committed or omitted. You need to do something in order that a crime may happen. On the other hand, not doing something might also tantamount to crime. Committed, and what you committed is forbidding under the law, that is a crime. Omitted, you did not perform or you did not do, but that is being commanded unto you that you will do it, but you did not do it, then that's still tantamount to a crime. So that is the nature of criminal law and a crime, which is the subject of this kind of law. Under this criminal law, it talks about the different nature of crimes, like felony, offense. So crime is generic in term, as we discussed a while ago. It is generic because crime might be a felony and an offense. It is a felony if the crime is against the revised penal code, and it is an offense if the crime is against the special law other than the revised penal code. In other contexts, felony is sometimes called mala in se. An offense sometimes called mala prohibita. Example of felonies are murder, homicide, theft, robbery, while offense are violation of Republic Acts, Batas Pambansa, and presidential decrees. So that's the difference between felony and offense. But both of these are considered crime under the eyes of law. Another is, under Law 1, it talks there where lies the power to define and punish an act as a crime. What particular branch of the government will say that your action is a crime? Will it be the executive, the judiciary, or the legislative? Obviously, it is under the power of the Congress that define and punish crime. Why? Because the Congress is mandated to create a law. And upon creating a law, it clearly specifies there the definition of that crime, the act you committed. They are the one who will define the crime you committed with your action. At the same time, in the law that they created, it also included there the punishment for such crime committed. So the power to define and punish an act as crime is vested on the Congress. Though the power is given to the Congress to define the act as crime, there are some limitations on the power of the Congress in relation to the enactment of penal laws. Number one is the law that will be created must be in general application. In other words, it must be applicable all or the entire parts of the Philippines. It should not be applicable to this province but not applicable to the other province. Hence, that law will be considered unconstitutional. Therefore, it must be in general application. Another is, it must not partake of the nature of ex post facto law. It should not partake the nature of an ex post facto law. Ex post facto law means that a law that covers or penalizes an act which is not yet a crime before or during the effectivity of the law. In other words, it is unconstitutional that the law created will cover those what happened in the past, because that will now be a clear violation of the Constitution, and that is called ex post facto law if the law will cover those action happen before the effectivity of such law. Another is, it must not partake of the nature of bill of attainder. Meaning to say, bill of attainder is a law that inflict punishment even without trial. So the law created must not partake to the nature of this bill of attainder. In other words, it must undergo the what you call due process. Again, bill of attainder is the infliction of penalty without trial. And it must not impose cruel and excessive punishment. So these are the limitations of Congress in the enactment of penal laws. How penal law are constructed? It is a general rule that a penal law is construed in favor of the accused and not on the government or the state. It is liberally in favor of the accused. Hence, with this principle of law, it introduces different doctrines, different principles on how they will liberally construe penal law in favor of the accused, such as the what you call equipoise doctrine. We have the vague for avoid for vagueness doctrine, and the what you call and the other maxim, the doctrine of pro reo, the nolium crimen, nolia poena sine lihi, and other doctrine supporting that the law must be liberally construed in favor of the accused. So in this construction of law, if the evidence is equal, therefore, the decision must be favorable to the accused. If the interpretation of the word is unclear or the meaning is vague, it must be favorable to the accused. If the word contains double meaning, one favorable to the accused and one making him feel harder, therefore the one favorable to the accused must be applied. Another, we have the doctrine of nolium crimen nolia poena sine lege. It literally means there is no crime when there is no law punishing the act. Meaning to say, it must be clearly stated that there must be a law punishing the act. Because even though the act is immoral in nature, but there is no law punishing that act, such act is not considered a crime. Nolium crimen nolia poena sine lege. There is no crime when there is no law punishing the act. Another, we have here what you call theories of criminal law. The theories of criminal law, these are the theories where the belief criminal law originated. We have here the classical theory. Under the classical theory, it is aligned with the theory on the school of thought of criminology. That in classical theory, that man is essentially a moral creature with absolute free will. Because of this free will, he will choose between good and evil. And that he has the free will to choose between good and evil, he must be responsible for the consequence of his act. If he chooses good, he must be rewarded. If he chooses evil, he must be punished. And under this classical theory, it's centered with punishment and retribution. That whoever committed the crime must be punished regardless of his age, sex, sanity, and other circumstances. And additionally, the nature of our criminal law is classical in nature. Why? Because as you can observe, in every crime, there is always a penalty imposed. And that is the very nature of classical theory. Another, the positivist theory, another school of thought of criminology. In this positivist theory, it talks about man is subdued occasionally by a strange and morbid phenomenon which condition him to do wrong in spite of or contrary to his volition. Meaning to say, under the positivist theory, it talks about rehabilitation. It is in contrary with the classical theory, because under positivist theory, it should not be focused on punishment, but rather to correct or rehabilitate the person who committed the crime. Because of the belief that there are some circumstances that push the person to do such act, like poverty, like uncontrollable fear, and this positivist theory give the existence of what you call exempting circumstances, mitigating circumstances, and others, or absolutory cause. Another is the what you call eclectic or mixed philosophy. Literally, it is the combination of positivist and classical theories. Under Law 1, another is the utilitarian theory in criminal law. Under the utilitarian theory of criminal law, it is also known as protective theory, that criminal law is made for the protection of the society. That is what you call utilitarian theory, that the law is made purposely for the protection of the society. Another important thing that you will know in criminal law, which I believe bulk of question during the board exam is being extracted, are the characteristics of criminal law. There are three characteristics of criminal law. First, generality or the general characteristics of law. Second, territoriality or the territorial characteristics of law. And the third is the prospectivity or the prospective application of law. Under the general law, the general characteristics of law talks about the law is binding to all persons who reside in the Philippines. The focus of these characteristics are all persons residing in the Philippines. You are residing, or even you are just only sojourning. You are a permanent resident of this country, or you are a foreigner. Once you are in the Philippines, you are covered by our criminal law. That is the general rule, that all persons, whether residing or sojourning, are covered by our criminal law when you are residing or sojourning in the Philippines. Exemptions. So here are the exemptions of general characteristics of criminal law. We lay down the general rule. Next, let's talk about the exemptions. The exemptions of general characteristics of criminal law is A, treaty stipulations. In treaty stipulation, it must be cleared in the treaty. It must be stipulated in the treaty, and that treaty will bind both countries. It will bind both countries, signatories of that treaty, that, for example, in our Balikatan exercise or the military exercise, if it is part of the treaty that if a soldier, an army from US, will commit a crime during the said training, in relation to the training, and he must be triable, and in the treaty stipulated therein that when he committed an act during the trial, during the training, and that soldier will be triable in his country. Therefore, if they have the Balikatan exercise, for example, in Subic, and he committed a crime during the military training, though the crime committed in Subic, he must be triable in his country because of the treaty stipulation. And another is the principle of public international law, covering the sovereigns, other chief of states, mga president, head of the states, ambassadors, minister, residents, charge d'affaires. These are covered by the principle of public international law. And in relation to Republic Act 75, this will be extended even to their domestics, their drivers, their cook, provided they are included in the list once they committed a crime in this country. For example, a president of the other country committed a crime in our country. The president of that country will be triable on his country, not in this. It's not subject with our criminal law. He must be subject on their laws, where he came from. So that is the principle of public international law. These are the two exemptions of general characteristics of law. So we know general principle and we must know the exemption. Another, the territorial application of law. Under the territorial characteristics of law, the law is binding to all crimes committed within the national territory of the Philippines. Kanina, in our general characteristics, all person residing or sojourning in the Philippines. Now in territorial, all crimes committed within the national territory of the Philippines. Therefore, the act for it to be punishable in our country, it must be committed within our national territory. Exemption of this is the Article 2 of the Revised Penal Code. The Article 2, which lay down the exemption of territorial characteristics of law, is also known as the extraterritorial application of law. General rule, the act must be committed here in the Philippines and it must be triable in our country. But if it's committed outside our country, general rule, it should not be triable in our country. That's out of our jurisdiction. But there are some crimes that, though committed in other country, can still be triable in our country. That these are the concern of Article 2 of the Revised Penal Code. Number 3 talks about the prospective application of law, meaning the law does not have any retroactive effect. The law is prospective. The law must, from the time of its effectivity onwards, it must not go backward. So it must be the moment or the time of its effectivity going forward. It should not be retroactive. That's the general rule. The exemption is if it is favorable to the accused. If it is favorable to the accused, it can retroact if it is favorable to the accused. The case of Robin Hood Carino versus people of the Philippines. Ruben Padilla, yung idol natin, wherein he is sentenced to suffer a penalty of 17 years to 21 years when he committed violations of PD 1866 or the illegal possession of firearms. But after that, a law was created repealing the new law from 17 years to 21 years. Here's a new law stating that the penalty now is 6 years for the violation of illegal possession of firearm. Though Ruben Padilla was convicted for that old law for 17 to 21 years, but here's come the new law saying only 6 years. It will now be the exemption of the prospectivity. Because the new law is favorable to him, then it will applicable to him. That is the prospective application of law. But it should not be applicable, though it is favorable, if the person is a habitual delinquent. Let's say, favorable sa kanya, but that person is habitual delinquent naman. All although it's favorable to him, that favored law will not be applicable to him. Next, we have the sources of criminal law, of course, the primary sources, the revised penal code, as well as the special penal laws. Again, presidential decrees, Batas Pambansa, Republic Acts, and others. Let's proceed to Article 2. Again, let's reiterate on the territorial application of law. These are now the exemptions. Number 1, what you call extraterritorial application. Number 1 should commit an offense while on the Philippine ship or airship. Yan. Talks about the ship and airship. First, it must be registered in the name of the Philippines. If the crime was committed outside the Philippines, general rule, it must be triable. If the ship or airship is within the Philippines, then general rule, it must be triable in our country. But the issue lies now on what if the crime was committed or happened when the ship or airship is outside our country. Diyan pumapasok yung tinatawag nating English rule and French rule. When we talk about English rule, if this ship or airship is outside our territory and crime committed inside, but the action only affects the internal management of the vessel or the airship, it's still triable in our country, although it's happened there. But, that's the English rule. But, if our ship or airship is outside our country and a crime happened and it affects the peace and security of that country, that crime now is triable in their country. Yan. So, if it only affects the internal management of the vessel or the airship, it will be triable in our country. But if it already affects the peace and security, then they will be triable in their country. So if it's internal management, here in our country. If it's affecting the peace and security, the country where it is situated. Should forge or counterfeit any coin or currency notes, the Philippine island or obligations issued by the government of the Philippines. You counterfeited our money and you make it in Hong Kong. Even though you make the counterfeiting in Hong Kong, but what you are counterfeiting is our Philippine currency, you are still viable in our country. That's the meaning of number 2. And number 3 should be liable for acts committed with the introduction of this island of the obligation and securities mentioned. Ganun din. If these obligations na pineke mo doon sa ibang bansa, gusto mong ipasok dito, then you are still liable. Although doon sa ibang airport ka pa nakuha. Number 4, while being public officer or employee, should commit an offense in the exercise of their function. Yes. If you committed the crime in relation to your duty, though the crime was happened outside our country, you are still triable in our country. For example, if I am a judge, or Mr. X is a judge, and here's come the accused, and ask Mr. X to give a favor in exchange of consideration. Let's say 5 million to drop my case. Then the judge said, okay, there is now an agreement. Then during the payment, Mr. X said, do not do that here. Let's go to Hong Kong, in Disneyland, sagutin mo yung mga plane ticket ko, doon tayo magkaliwaan. And at that point, they go to Hong Kong and doon nagkabayaran. not knowing na nababaybas na pala sila at nagkaroon ng hulihan, though the crime committed in Hong Kong and the judge or Mr. X is an employee or a government official of our country, still he will be triable in our country. Another should commit any crimes against national security and the law of nations. Yan. If the crime committed, though it's committed in other country, if that is against the national security and law of nations, like treason, espionage, it will be triable in our country. So that talks about Article. Another talks about Article 3. It talks about felonies. An act or omission punishable by law are felonies. Of course, for a crime to be a felony, there must be an act. And again, as I said a while ago, there must be an act committed or omitted in violation of a law. That is a felony. And a felony must be violation of revised penal code. Yeah. The felony may be intentional or unintentional. The what you call with malice or with culpa. The intentional felony, culpable felony. Another is Article 4. The criminal liability shall be incurred. Sino ang paparusahan? Of course, the one who committed the crime. That's general rule. If you are the one who committed the crime, you must be criminally liable. And although the wrongful act be different from that which you intended. First, it's simply you committed a crime because you want to commit it. You intend it. At the same time, you do not intend to commit, but still, you are the one who committed it. Yan. So, under this paragraph number 1, we have here the mistake in identity or the what you call error in persona. Mistake in the blue or the what you called aberratio ectus. And the third one is praeter intentionem, or the injury suffered is greater than what is intended. Number 1 is mistake in identity or error in persona. Number 2, mistake in the blue, aberratio ectus. Number 3, praeter intentionem, or the injury suffered is greater than what is intended. These are the 3 common examples by a person committing a felony, although the wrongful act done be different from that which he intended. Yan. Mistake in identity, meaning to say, ibang nabaril mo. Akala mo, si Juan, yung dumaan in a dark alley, then when you shoot this person, it turned out to be Pedro, your father. Still, you are liable. Though your intention is killing Juan, but who you killed is Pedro, that's mistaken identity. You are liable for your action. Another is mistake in the blue, or the what you called aberratio ectus. Yan. You want to shoot A, but you hit B. Mistake in blue, aberratio ectus. Another is praeter intentionem. The injurious result is greater than that you intended. For example, you want to slap A, but upon slapping A, you want to evade that slap, but he turned down and tumama sa pavement. That causes his death. Still, you are liable. Your intention is different from the injury suffered. That is what you call praeter intentionem. This explains paragraph. And mistake in identity, mistake in the blue, and praeter intentionem, you are liable because of doctrine of proximate cause. You who is the cause of the cause is the cause of the evil cause. Yun. That's why, iba naman yung gusto kong gawin, pero yun ang nangyari. Ito ang nangyari. This is the explanation. You who is the cause of the cause is the cause of the evil cause. The doctrine of proximate cause. Hence, they must prove that you who cause, and that cause must be adequate and efficient as to the natural order of events. Yan. Ikaw talaga ang dahilan. That's why you are liable. That talks about paragraph number 1 of Article 4. And paragraph number 2 of Article 4 is the ironic provision of the revised penal code, the what you call impossible crime. Impossible crime seems ironic, nakakatawa, but still you are liable by any person performing an act which would be an offense against person or authority. I want to emphasize this, that the crime must be against person or property, were it not for the inherent impossibility of its accomplishment or on the account of employment of inadequate and ineffectual means. Kaya hindi mo nagawa yung krimen. That is what you call impossible crime. For example of impossible crime, you cannot kill a dead person. Hindi mo na pwedeng patayin yung patay na tao. Mr. A want to shoot Mr. B, not knowing that Mr. B died a day before such action. Patay na pala siya bago mo siya patayin. Na-stroke na pala. Autopsy reveal, ganun. Then, that is impossible crime. Hindi mo kasi pwedeng patayin ang patay ng tao. Pangalawa, you cannot steal what you own. Nakaw ka kasi because of desperate, na wala kang pera. Sakto yung ninakaw mo, tinignan mo. You look at it and you say, this is your wallet pala. Ganun din sa relo mo. Ninakaw sa'yo yung relo mo, after a while, nagnakaw ka rin, then you found out na yung ninakaw mo, relo mo rin pala. These are the simple explanation of impossible crime. But, you are still liable. Sir, bakit? Because of what you call criminal propensity, or the what you call criminal tendency. Na kung hindi lang sa'yo yun, kung hindi lang namatay din yung tao na gusto mong patayin, you committed the crime. So, that is impossible crime. You are still punishable of aristo maior. The punishment is for your criminal tendency and criminal propensity. That's what you call impossible crime. And take note, it's only applicable to crimes against person and property. Yeah. Is Article 5. Whenever a court has knowledge of any act which may deem proper to repress and which is not punishable by law, shall render the proper decision and shall report to the Chief Executive through the DOJ the reason by which the court to believe that said act should be made subject of legislation. So under the criminal procedure, what will the judge do, if this will be the case, is to acquit the accused, adhering to the principle of nolium crimen, nolia poene sine lege. Though let's say the action is wrongful or immoral, but there is no law punishing that act, the court will acquit the accused. They will dismiss the case because adhering to the principle of nolium crimen, nolia poena sine lege. But what will the court do? It shall inform or report the president, the chief executive, through the office of the DOJ, that there is a need to make a legislation. Kailangan magpagawa ng batas para ma-penalize yung kaso na yun. Yan. Or else, he will be acquitted. Like in the case of the I love you virus. The person who spread the virus was acquitted simply because during that time, the court cannot find law that will penalize that. Then that's the origin of na-create yung cybercrime, ganyan, nag-conceptualize na rin sila. Another is Article 6. Take a look with this. Consummated, prostrated, and attempted. Yan. A felony is consummated if you perform all the elements. As simple as that. You perform all the elements stated by the law, then that is consummated. Prostrated, when you perform all the acts, but you do not produce it by reason of causes independent of the will of the perpetrator. All you know, you perform all the acts, akala mo patay na. But there are things happen, independent to your will. Biglang may dumaan na tao. Tinulungan siya, pinagamot, nabuhay. Yun. There is cause independent to your will. Kaya hindi mo nagawa yung buo. And that is called prostrated. While attempted, you just started. You did not perform all the elements. Maybe you performed the one element, perform it by overt acts, but you did not successfully fulfill all the elements. That is just only an attempted. Yeah. So those are the difference between the three. Consummated, simply napatay mo, yun. You perform all the elements. Prostrated, you perform all sa tingin mo, but nagkamali pala, you did not produce it by reason or causes independent to your will, that is prostrated. Attempted, you did not perform. You just started with overt acts, but you did not perform because of some causes or by accident. And these are, it should not be because of your own spontaneous desistance. Because if it is not by other causes or accident, but it is due to your own spontaneous desistance, you are not liable for attempted felony. Because the spontaneous desistance, yung pagbawi mo, pinunas niya na yung intention mo. Ganun din. Same is true with the prostrated. It must be independent to the will of the perpetrator. Sinaksak mo si Mr. A. Then, iniwan mo na siya doon. May ibang taong nakakuha, pinadala sa ospital na buhay. That is prostrated. Pero nung sinaksak mo, nagmakaawa siya. Kung binaril mo, nagmakaawa siya. The point of death, nagmakaawa. Naawa ka rin. Tinulungan mo rin lang. Ikaw nang nagdala sa ospital. Therefore, it's not independent to your will. It became dependent to your will. Ikaw na eh. So, it is not already prostrated. It will now turn the crime into physical injury doon sa situation natin. Yun. Yung pagtulong mo sa kanya, pinunas niya na yung intention mong patayin siya. But we cannot deny the fact that he suffered the injury. That's why, if that will be the case, the crime committed is physical injury already. So, these are the different points that you will know under Article 6. Another, we have the stages of the commission of the crime, of course, the attempted, frustrated, and consummated. We discuss. Article 7, light felonies are punishable only when they have been consummated, with the exemption of those committed against person or authority. Meaning to say, light felonies are only punishable when they are consummated. That's the general rule. Why? Because light felonies, the penalties are too small. Tapos i-chop-chop mo pa, wala nang matitira. That's why light felonies are punishable only when they are consummated, with the exemption of crimes against person or property. Sometimes kasi specified. Yan, pag crimes against person and property or sa otherwise provided by law. If it is clearly stated by law that this penalty is for prostrated light felony, kung may mga ganun, or attempted light felony, if the law so express, then yun pwede. But general rule, light felonies are punishable only when they have been consummated. And another article is Article 8. Conspiracy and proposal to commit felony are punishable only in case in which the law expressly provide a penalty thereof. Conspiracy, when there are two or more persons who comes to an agreement and decide to commit it, that is conspiracy. Proposal, when he has decided to commit it and propose it to other. Yan. If they did not agree, doesn't matter. What matter there is she proposed, and that is proposal. While in conspiracy, you propose and both of you decide to commit. That's conspiracy. But general rule, take note. Conspiracy in general is not prohibited by law because you cannot punish an internal acts. The mere planning, wala pa yan. But once there is an overt acts, diyan pala magsisimula. From preparatory acts going to acts of execution. So general rule, conspiracy and proposal are not punishable. Yan. Except when the cases the law specially provides. There are some specific laws like conspiracy and proposal to commit treason, rebellion, insurrection, sedition, and others. Codita, yan. Kidnap for ransom, and even terrorism. These are the specific laws where conspiracy and proposal are punishable. But general rule, conspiracy and proposal are not punishable under the law. Yan. Except if these crimes are clearly specified by our law. Article 9, the grave felonies, less grave, and the light felonies. Dito ang titignan natin dito, we will see about the punishment and the fine. Yan. Yung parusa at yung multa. Okay? Under the grave felony, the penalty must be capital punishment and the afflictive. Capital punishment, death penalty, and the afflictive penalty comprising the prisión mayor, reclusión temporal, and reclusión perpetua. So in other words, under grave felonies, the penalty must be more than 6 years. More are those which the law punishes penalty with a maximum period of which are correctional. Yan. So in least grave, we have there the Aristo Mayor going to correctional. Yan. So meaning to say from more than 1 month to 6 years. Yan yung less grave felony. While in light felony, yan yung 1 month below. Yan. So, these are the differences. We have here the new law with regard to the fine na yan actually ng RA 10951, amending some provisions of our revised penal code. Pinataas na. If that is afflictive, then that we are grave, that is 1,200,000, exceeding 1,200,000. Yan na yun, yung bago. Then correctional, not exceeding 1,200,000, but not less than 40,000. That's now our correctional. And our light, less than 40,000. This is now the new provision under RA 10951, amending those provisions of law. Another Article 10, offense in which are or in the future may be punishable under special law are not subject to the provision of this code. This code shall be supplementary to such law unless the latter should specifically provide the contrary. Meaning to say, in this article, the issue here is what prevail? Is it the special law or the criminal law? In case there is the application of the two. So if there is now the possible application of the two, then what concurs or what prevail is the special law. Yes, the revised penal code will only be supplementary of the special law if it still can be applied. Meaning to say, ang unang i-apply because there is now a special law, then the special law will prevail. For example, our drug law. We have our drug law in our revised penal code, but because of Republic Act 9165, here's come. The applicable now is RA 9165. And kung may kulang doon, and that can be found in our old law, then pwede rin i-apply. But generally, usually ang ina-apply dyan is the special law. The revised penal code will only be a supplementary to the special law. Yan. If they cover same act. Another is the, let's summarize it, Article 11, Article 11, 12, 13, 14, 15. Yan. Another important provisions of the revised penal code, the so-called circumstances affecting the criminal liability. Yung tinatawag mong GIMA. Justifying, exempting, mitigating, and alternative. Justifying, GIMA, justifying, exempting, mitigating, aggravating, and alternative. Then, you can find there in my presentation the summary. Yan, the mnemonics, so that you cannot, you will not forget what are those different circumstances under justifying, exempting, mitigating, aggravating, and alternative. Yan, to make it short, we can discuss that for other further discussion if we have given enough time. And for example, I will give you example. In justifying circumstance, senior sapub. Senior sapub stands for S, self-defense, R, defense for relatives, S, defense for stranger, A, avoidance of greater evil or injury, F, fulfillment of duty, O, obedience of lawful order, and the new one, letter B, battered woman syndrome. That's how you will make the memorization of these circumstances under justifying. Yan. Exempting circumstance, yan, I use inaccu, something like that. Yan. I, imbecility or insanity. N, covering two paragraph, the non-age or yung minority. A, accident. C, uncontrollable. C is compulsion of irresistible force. U, uncontrollable fear. I, indispensable, insuperable cause. So yun. So mga ganun lang. Mitigating and so on and so forth. Ang marami, it's aggravating circumstance. Yan, 21 yan. Akra, po, car, pida, chuba. Something like that. Advantage by position, contempt, mga ganun. Rank, age, Yan. Recidivism, reiterasyon, mga ganon. Price, inundation, yan. Ignominy, unlawful entry, breaking walls, aid of minor, cruelty, evident premeditation, and others. Ganun lang yun. Meron yan. Alternative circumstance, yung red. Relationship, intoxication, degree of instruction, and degree of education. So these are the summary of Article 11, 12, 13, 14, and 15. So with that one slide, it covers the summary of those provisions. And there are two additional, what you call absolutory cause that you can find on in different articles, like yung mga accessories exempted, death or physical injury under exceptional circumstances, something like that. Then extenuating. Extenuating are those mitigating which are not included or enumerated in your mitigating circumstances. Yan yung extenuating. Having effect like mitigating also. But just because they are not included under those enumerations, but they have the same nature. Dito pumapasok yung sa letter A, yung analogous circumstances. It's not clearly enumerated here, but those analogous circumstances can be considered extenuating circumstances. Yan. So, these are talking about the meat of this article. These different circumstances affecting criminal liability, also known as the JIMAA, the justifying, exempting, mitigating, aggravating, and alternative circumstances, have their own basis and effects on the criminal liability. In justifying, the effect is that there is no crime and there is no criminal liability. There is no crime and there is no criminal in this circumstance. And because there is no crime and there is no criminal, there is no criminal liability. At the same time, there is no civil liability. That's the effect of justifying circumstance. There is no crime and there is no criminal. There is no criminal liability and there is no civil liability. Except in paragraph number 4, the avoidance of greater evil or injury, or the what you known as state of necessity. The person will become civilly liable in this paragraph because of the benefit he received from that situation. So yun lang. So in this paragraph, in these circumstances, no criminal liability, no civil liability, except in paragraph number 4, wherein there will be a civil liability because of the benefit he received from the situation. Justifying circumstances, the basis is the person did not transgress the law. There is no transgression or violation of law. In other words, the act of a person is said to be lawful. There is no transgression of law. That's why there is no criminal liability and there is no civil liability. In exempting circumstances, there is a civil liability, but there is no criminal liability. There is a civil liability, but there is no criminal liability. What's the basis of exempting circumstance? The basis of exempting circumstance is there is a complete absence of freedom, intelligence, intent, imprudence, and negligence. So totally, there is a complete absence of the elements of the felony. the freedom, complete absence of freedom, complete absence of intelligence, complete absence of intent, and complete absence of negligence or imprudence. Because of that, the person is not criminally liable, but he is civilly liable under exempting circumstance. Under mitigating circumstance, there is a certain similarity with exempting, but it's not totally complete absence. There is just only one thing. There is lacking in the freedom, intelligence, intent, negligence, or imprudence. Because there is one thing and there is lacking on these elements, the freedom, the intelligence, intent, imprudence, and negligence, the effect of mitigating is to reduce the penalty. It will not totally extinguish, but it will reduce the penalty. It reduces the penalty because there is lacking or wanting on these elements. The application of mitigating can be a privilege mitigating or it can be an ordinary mitigating. It depends on how. So yan, paano yung gagamitin? Incomplete justifying and exempting. Then minority, the praeter intentionem, the provocation, the vindication, the plea of guilt, the voluntary surrender, physical defects, illness, and other analogous circumstances. So all this will reduce the penalty. Next will be the aggravating circumstances. These aggravating circumstances is the contrary, or it's the other way of the mitigating. If mitigating will reduce, aggravating will increase the penalty. The presence of aggravating will increase the penalty or elevate the crime, or it will catapult the crime onto a higher category. That is the nature of aggravating circumstances. It might be generic, specific, inherent, or qualifying. These are the four categories of aggravating: generic, specific, inherent, and qualifying. The effect of aggravating will increase, as I said. What's the basis? Why there's a need to increase? The basis is because of the greater perversity of his act. The greater perversity of his act. There is a greater perversity. You committed the crime. Pinatay mo siya in front of his loved one. That's ignominy already. Pinatay mo siya. Tinadtad mo. Yan. Overkill. That's cruelty. Use of explosions. Use of poison. Yun. There is what you call, there is a greater perversity, and that will result to a higher penalty. And the last is the alternative circumstances. The alternative circumstances, the effect is either it will mitigate or it will aggravate. It either mitigate or it's either aggravate. It depends upon the presence of this alternative circumstance and how it used during the commission of the crime. Like for example, relationship. If the crime committed is against person or chastity, relationship is aggravating. If the crime committed is against person or chastity, the relationship will be considered aggravating. If the crime committed is against property, the relationship will be considered as mitigating. It will reduce. Crimes against person and chastity, it will increase. Crimes against property, it will decrease. That is how the relationship. In intoxication, if you are habitual drunkard, it will increase. If you are habitual drunkard and you use intoxication to bolden your self in order to fulfill the crime you want to commit, that will increase or that will considered aggravating. But during the commission of the crime, you are under the influence of liquor or you are intoxicated, but you are not habitual drunkard. And the intoxication has nothing to do with the crime. It did not involve you, that bolding you. So that intoxication will consider mitigating. The degree of instruction or education, the higher education you have, then when you committed the crime, it can consider aggravating. But if you did not attend the school, you did not finish any schooling, and you committed the crime, that can be an alternative circumstance. So these are the basis and the effects of these different circumstances in the criminal liability of a person. And again, the absolutory cause, from the word absolutory, it will absolve you. Absuelto ka dito, because the law says so, that there is no penalty to be imposed of your action. Yan. As I said, accessories exempted to criminal liability. Yan. Death under exceptional circumstances, even instigations, these are absolutory cause. We have also extenuating circumstances having an effect of just like mitigating circumstances. Again, it so happened that they are not enumerated, or extenuating again is those falling under analogous circumstances. So these are the effects and the basis of the differences affecting criminal liability, covering Article 11, 12, 13, 14, and 15. Now let's proceed with the Article 16. The Article 16 introduces the persons who are criminally liable in a grave, a less grave, or a light felony. To make it in general, these are the three categories of persons who are criminally liable under felony. If you committed a felony, you can be considered a principal, accomplice, and even accessory. Principals, accomplices, or accessories. It also covered the different next articles, 16, I-17, 18, 19, and 20, talking about the nature of these persons criminally liable. So let's distinguish the three. Principals. Principals can have different kind. It can be divided into three. We have there the principal by inducement, principal by direct participation, and the last one is principal by indispensable cooperation. All these three are the different kinds of principals. Again, if they will ask you to define principal, principal is a person who have directly participated, induced, or indispensably cooperated during the commission of the crime. All these are considered principal. If you directly participate, if you induce, and there is the what you call indispensable cooperation. I will give you example of illustration of these three principles. A wanted to kill X. A wanted to kill X. A looked to B and offered a 1 million pesos, asking B to kill X. There's an agreement. Both agree. Pumayag si B na patayin si X dahil sa offer ni A. Yan. Then, nung hinanap ni B, searching for X, B searched for X. and nalaman niya that X was in an isolated island, sabihin nating El Nido, pinuntahan niya. Yan. And pagpunta niya doon, then the only way to go there is through the boat. Bangka. Yun lang yung isang paraan para makapunta ka doon sa island na yun. At nung dumating si B, gabi na. And there is only one boat at that time. At padaong na siya. The boat will dock. Wala nang biyahe. But B as C, the owner of the boat, to bring him on that island because he is looking to X. And he will kill the latter. C agreed because of the offer to triple the price. Yan. So, they both agreed. Then, eventually, when they arrived there, B killed X. So, what are the participations of the three? All of them are principal. A, who induced and give 1 million to B, is principal by inducement. B, who killed X, is principal by direct participation. And C, the owner of the bangka, whose the only way to go there, is principal by indispensable cooperation. So this is the clear illustration of the three. Next, we have accomplices. Accomplices is a person who, prior or simultaneous in the commission of the crime, he participated. Accomplices, itong mga ito, hindi sila magpo-fall under indispensable cooperation. Yan. They cannot qualify themselves as indispensable cooperation, principal by indispensable cooperation, so they will consider accomplice. Why? Because they are there prior or simultaneous to the commission of the crime. For example, prior to the commission of the crime, hiniram sa'yo yung baril mo kasi yun ang gagamitin sa pagpatay sa tao. Then you are accomplice pag pinihiram mo. Yan. But you are not there on the crime scene. You just lend your firearm, you can be considered accomplice. Or, you, Mr. A, have a struggle with Mr. B. Yan. You are struggling with each other, nag-aaway kayo, bugbugan, yan. You are A, and nakipagbugbugan ka kay B. On the point of struggle, dumating si C. Wherein si C, mayroon palang kinikimkim na galit kay B, yung kalaban mo. Then, sinaksak niya si B. At namatay si B. So, you are there fighting against B, but here comes C. Siyang sumaksak, namatay si B. Yan. Nasaksak na nga, bubugbog mo pa. And autopsy revealed that the cause of death is the stab wound suffered by B. So, C is now the principal by direct participation. You are there simultaneous to the commission of the crime. You are accomplice. That is accomplice. And the last is accessory. Accessory, if you profited or benefited in the commission of the crime. It's important that you know that you are benefited from these things from the crime committed. Then you harbored the criminal, tinago mo, or even you conceal the evidence that can be used against the person. So again, you are benefited or profited from the commission of the crime. You harbor the person who committed the crime, and you destroy or you conceal the evidence used by that person in the commission of the crime. So you are called accessory. Yeah. So these are the different persons who are criminally liable. Another On Article 21, kasi from 16 to 20 talks about persons who are criminally liable. Yun yung pinag-usapan natin. Now, if we proceed to Article 21 to 113, umiikot na lang yan on penalties. It talks about the different penalties imposed, the effects, yan, what will be the effects of the penalty, the scale of penalty. Yan, ikita mo dyan yung scale ng capital punishment, afflictive penalty, correctional penalty, as well as the light penalty. You will encounter here the aristo minor, aristo mayor, the prisión correccional, the prisión mayor, the reclusión temporal, reclusión perpetua, and death. So ito yung dinidiscuss dito sa Article 21 onwards. Yan, the scale of penalty. In this scale, nandyan yung the types of principal penalty, at the same time the accessory penalties. Yan. The duration of penalties, the range, gaano katagal makukulong. Like for example, in aristo minor, 1 day to 30 days. Yan. Aristo mayor, 1 month, 1 day to 6 months. 1 month, 1 day to 6 months. Aristo mayor yan. Prisión correccional, 6 months, 1 day to 6 years. 6 months, 1 day to 6 years. Prisión correccional. Prisión mayor, 6 years, 1 day to 12 years. 6 years, 1 day to 12 years. Reclusión temporal, 12 years, 1 day to 20 years. And reclusión perpetua, more than 20 years. So these are the durations of this penalty. You will know whether that's a capital punishment, afflictive penalty, correctional penalty, and light penalty. This will also determine the classification, whether that is a grave felony, that will be a least grave felony, or less grave or light felony. Yan. If that is aristo minor, light felony yan. If that is reclusión perpetua to correctional, that is less grave felony. Prisión mayor, temporal, and reclusión perpetua, this is grave felony. Even that those sentenced with death are grave felonies. So yan. Then we have there the aggravating and mitigating. The effect of penalty, its application in relation to the circumstances. Yan, sabi nga natin kanina, it will increase, it will decrease. So we will know saan babagsak. If it aggravate, of course we will get the minimum. If it will mitigate, we will get how is the reduction. Whether it will go down, depending upon the presence of mitigating, and depending the nature of mitigating, whether that is a privilege or ordinary. So, doon natin malalaman yung period, degree, yan. So, kita natin dyan yung minimum, maximum, medium. Yan, yung maximum, medium, minimum. So, ito yung mga pinag-uusapan sa penalties. Yan. And total and partial extinction of criminal liability is also covered by this article. The total extinction is that mawawala yung parusa mo. There are different grounds, like death. Of course, if you die, then there's no more person to be penalized. So, total extinction na yan. Then, you serve your sentence. Logically, you serve your sentence, okay na. Tapos na eh. Na-extinct na yung parusa mo. Amnesty. Yan. Amnesty, it is a form of executive clemency in a form of general pardon with the concurrence of the Congress. And we have also the absolute pardon given by the President as an act of grace. And we have also the prescription of crime. Nag-i-expire din ang krimen. Parang gamot yan. Once hindi yan na-file, then it will expire depending upon the penalty imposed. Depending upon the penalty imposed. And prescription of penalty. Yan. Kailangan mahuli ka pag ikaw ay nakatakas. Because kung hindi ka nahuli, then there will be a forfeiture of penalizing you. Depending again the penalty imposed. Yan yung prescription of penalty. And the last is the marriage of the offended party. Asawahin mo just to seal the lips, to totally extinguish you from criminal liability. These are the grounds for total extinction of criminal liability. And we have also the partial extinction. It will not totally extinguish, but it will partially remove part of your penalty, like conditional pardon, good conduct time allowance, and others. So these are different topics related to penalties.